And our next session, name of our next session is Third Time Lucky. And we all know that most of our daily work is dedicated for the resolution of sort of different disputes. So once it is impossible to find a solution while we are just negotiate, then the parties are forced to litigate or find another ways how to solve their problems. So today we have 4 speakers, one still missing, but I think he will, yes, we have everybody here. I will give a floor for the first speaker, Catherine Bazil. What is interesting, she's originating from Europe in spite of currently she is not living here. So she also is a member of ECTA Law Committee, and she's a partner of Novak and Deuce. She's very high experience in a settle of numerous trademark infringement cases. Next speaker will be Ignacio de Castro, and he's a Deputy Director of Administration and Mediation Center of WIPO. So both of them will speak about the mediation and the power of negotiation and settling disputes in another way. So please, the floor is yours.
Good morning. Thank you very much for inviting me today, and maybe more people will join us as they realize that the coffee break is over. But I'm pleased to be here. It's my belief that many, if not most, of the trademark infringement cases that I've seen or that we experience can actually be settled and should be settled. Usually there's a party who cares more than the other party about the trademark, or there's somebody who has more money, or there's some business motivation that can lead to a resolution. So I'm really pleased to have a chance to speak to you about mediation today. And Ignacio and I divided our time where I'm going to talk a little bit about what mediation is and some of my tips for having a successful mediation or potentially successful mediation. And then Ignacio is going to talk about WIPO and the mediation services that they can offer and the things that they're doing. Let's see. Trademark disputes, like other IP disputes, can be legally and factually complex. They can be complex just within one jurisdiction, or they can be a multi-jurisdiction dispute that becomes complex either for different legal consequences, or just the sheer fact that you're working in trying to settle something in multiple jurisdictions. As a result, the costs attendant with a legal dispute can be quite high or significant. And they can be particularly high in jurisdictions that have processes like discovery and other ways of handling the litigation that take a lot of time and a lot of resources, both in terms of using external resources like outside counsel, or internal resources where you have to take your time away from business in order to develop your evidence and your information and your facts. Using mediation offers distinct advantages to the parties. Mediators do not sit in judgment of a dispute. I mean, you certainly can, in different jurisdictions, you can have a mediator that may be a judge or a magistrate or a former judge or magistrate, and they can certainly bring the ability or the experience of having judged disputes before, but that's not really the purpose of a mediator. A mediator is there to help facilitate and try to bring the parties to a point where they can settle the dispute. When considering mediation, I think it's very important to consider what the dispute is about. I mean, in the case we're talking here, it could be a trademark infringement dispute, but it's usually more than that. I mean, that's the legal context for the dispute, but the facts, the business relationships, whether there are other aspects to it, contractual aspects or things like that, all play into what kind of mediator you might want to use in having a mediation. Mediators tend to come in sort of three styles, if you will. And I'm looking here to see if my slides. They tend to come in three styles. There's the facilitative mediator, the evaluative mediator, and the transformative mediator. A facilitative mediator is preferable in situations where the parties are having communication difficulties, or maybe they have underlying issues to address that really need to be discussed and worked through. And so generally a facilitative mediator can help the parties maybe think outside the box, come up with some creative or different ideas, but again, the idea is to facilitate the conversation and a communication between the parties. An evaluative mediator may be someone who's acting a little bit more like a judge in the sense that they are actually trying to take an active role in evaluating the situation of the case, maybe the pros and cons, the benefits of different outcomes, but it's more of an evaluation situation. And a transformative mediator is somebody who usually helps or may help when there's really kind of what I call relationship issues, although they can also be called issues of principle, maybe where you have the parties standing on principle, or there is some underlying contractual or business situation which is really causing them to not be able to see outcomes other than just fighting the whole thing through to the bitter end. I think when most people think about mediation, they think of the facilitative style of mediation. And there are mediators, of course, who will put all three styles together depending upon what's going on. And mediation can be in many different forms. I mean, you can have a mediation where you come in and the parties just sit down and talk. You can have a mediation where often the mediator will sit down with both sides. Each side will have written some kind of explanation to the mediator so that the mediator will have both the context for the matter that's at hand, and also there's often a confidential submission, so the mediator will actually know a little bit more about each side that's not being shared, at least shared right away. And then often what might happen is that then the mediator will take the parties off to different rooms and shuttle back and forth between the two, which really allows the parties to talk individually and allows the mediator to go back and forth and to really kind of work the situation and seeing what they can do to bring the parties together. Another consideration is whether you do need a mediator with expertise or what kind of expertise. In many of the cases I've had that we've ultimately settled, we've often had a former judge who has tried trademark cases and has a fair amount of experience in intellectual property or contract disputes as well as trademark disputes. But there are times when I actually don't want someone who's particularly well-versed in trademark law, or so well-versed in trademark law that they won't see it from any other perspective except from a narrow trademark law perspective. I mean, for example, I have a case right now where the alleged infringement has to do with the name of the Golden Gate Bridge. And the transportation district that manages the Golden Gate Bridge itself and sells souvenirs and things like that on its website has sued a small individual artisan who manufactures furniture. And he uses the name the Golden Gate Bridge Furniture Company, and he uses a website called ggbfurniture.com. And the reason he uses all of that is because in 1994 he bought the section of the Golden Gate Bridge railing that was replaced by the Golden Gate Bridge Transportation District. And so his furniture is actually made from this steel that's an authentic Golden Gate Bridge steel. And from my perspective, at least for the upcoming mediation we're going to have, would be to have a judge or someone who is not so focused on trademark law that they won't be able to see some of the other arguments, the fair use arguments, the potential free speech arguments, the fact that, as my client often jokes, no one has ever walked up and asked them if they can pay him the toll to cross the bridge. So, there are times when you really do need to think about what the sort of underlying issues are and where you're hoping to go with the mediation in terms of who you're choosing for your mediator. To prepare for the mediation, it's really important to understand both sides of the dispute as best as you can. You need to be able to understand some aspects or really put your shoes on the side of the other party, because if you can't do that, you're not really going to be able to figure out creative ways to settle the case. You also need to establish your best alternative to a negotiated agreement, BATNA, and your worst alternative to a negotiation agreement, so that you can understand what the benefits are of settling the case, what the risks are of not settling the case, and because, of course, without that, you really can't evaluate what you should do. And again, it's very important to have some flexibility and understand where the other side is coming from. I also think it's very important that when you're in the mediation that you state your case reasonably. I think that you have to be an advocate for your client. It doesn't mean you don't advocate. It doesn't mean you give up your legal positions or anything like that. But if you come in completely absorbed in your own advocacy, then you might overstate your case, you might push things too far. And my experience so far is with many mediators is that they appreciate having a party who appears reasonable. And I, knock on wood, I've actually been pretty successful so far with most of my clients in ending up with a settlement that's really made them very happy. And that's been done by being reasonable, asking my client to be reasonable, and looking for some really creative business solutions or non-business solutions that lead to maybe a different result than everyone saw when they first filed the lawsuit. Which basically in the end was what I consider to be interest-based negotiation. Because if you're really looking at your client's interests and the other side's interests, then usually you can find something. Now, not all cases will settle in mediation. We heard about the chocolate companies earlier. It sounds like the chocolate companies, may not be willing to settle. And there are certainly cases where either the emotions won't allow it to happen, or everyone is truly committed to their trademarks in a way that it's just not possible. But like I said, I really believe that if you are able to bring the parties together and look for some alternatives and really force people to look at what the worst alternatives are and the best alternatives are if they were not to settle, and then look for choices in terms of what they can settle, you will find a likelihood of settling. And then lastly, I think an important thing to keep in mind is what you bring with you to the mediation in terms of evidence. We're fortunate in that we're trademark attorneys. So there's often an opportunity to bring in product or examples to give the mediator a real feel for what the marketplace might look like or what the likelihood of confusion may or may not be. Just another quick example, I had a case several years ago where my client's mark was A5 and the other party's mark was O5. And so what we were able to do was really go out in the market, and it was clothing. We were able to go out in the marketplace and find examples of clothing where there were other uses of O5. This was also in 2004, which meant there were going to be a lot of future uses of O5 when we got to 2005. We were able to find, it was really nice. The mediator walked in and there was this sort of all this clothing laid out, and it really helped influence his viewpoint without us having to sound strident or appear unreasonable. It really helped us set the context for the case. So I think if you think about the kind of evidence you have and how you can make a presentation to the mediator and to the other side. Often, sometimes it's for, at least, again, when I was in-house at Levi's, one of the examples that often worked was just sitting there and listening to the other side explain to me why it wasn't fair or why we were picking on his company. And sometimes that's all it took was going to the table and letting someone else express their view and knowing that they had brought a large company to them to hear their viewpoint, and then you can move on to settle the case. So there's a lot of different ways and a lot of different things to think about, but I do believe that mediation really is an excellent way to address your client's needs. Thanks.
Good morning. Thank you, Kathy, for setting the scene on mediation. Thank you also to ECTA for inviting me to participate in this meeting. What I'm going to be doing in the limited time available is just to provide a brief update of the work of the WIPO Arbitration and Mediation Center in the area of mediation, and particularly as it relates to trademarks. Apologies also for not using the model presentation. I just noticed that I must be the only one so far not to do so. Doesn't seem to work. Here we go. Okay, so I think everyone knows exactly what WIPO is, so I'm not going to go into that. The Arbitration Center really focuses on resolving disputes, IP disputes, and we have different procedures to do this. Okay. Mediation, Kathy has already explained very well what mediation is. Really, the big advantage of mediation, as Kathy explained, is that you go beyond what she described as the narrow legal issue, the trademark issue in this case, and you go more into a business solution of a particular problem, and the mediator is a facilitator in this process. Arbitration is a different procedure where you get a decision, an arbitration award, which is internationally enforceable through the New York Convention, and expert determination is more for technical disputes, particularly in the area of patents, determination of royalty rates, assessment of damages, technical issues. So the expert may not be a lawyer, and the decision of the expert will not be an arbitration award, so it will not be internationally enforceable. What we offer is different provisions which allow parties to resolve their dispute through an escalation mechanism. So there will be clauses which provide for a first phase of negotiation, then moving to mediation if the parties cannot reach a settlement in the negotiation phase, and then moving to arbitration. And this is what we see in more than 30% of cases. What we see is a first phase of mediation, and if the parties do not find a settlement in the mediation phase, then they will move to arbitration. This has the advantage that when the parties have this clause in their contract, maybe a license agreement, a coexistence agreement, then if they are forced to take very seriously the mediation phase, and it achieves a higher level of settlement because parties know that if they don't take the mediation seriously, there will be an arbitration following, and then the arbitrator will decide the case. Our role as an institution, as the Arbitration Center, is to help the parties in the process, and fundamentally our main role is the appointment of the mediator or arbitrator. And for that we have a list of neutrals who are external people. Some of them are sitting in this room. Peter Muller, Luca Barbero are some of our mediators, and we believe really that it is important in many of these IP-related cases that the mediators have got substantive knowledge about the area in dispute. So if it's a trademark case, we will propose to the parties the appointment of a trademark lawyer. If it's a patent case, a patent lawyer, etc. So what we do is we propose these mediators and we try to make the process as efficient as possible. This is just a distribution of the types of cases, and as you see, patents is the main area that we deal with, and trademarks is 14% at the moment, but we are seeing a growth in trademarks. We also are seeing quite a big growth in the area of IT and telecom, but I will not talk about this today. In terms of business areas, you see here IT is very big, mechanical, pharma tend to be the biggest cases. I'm having trouble moving the slides. But here you see the types of disputes that we see are mostly contractual, and they tend to be licensing disputes, research and development agreements, coexistence agreements in the area of trademarks. We're also seeing an increase in infringement cases where the parties may be involved in litigation and move to mediation. And this we are seeing increasingly. We used to see cases coming from the US courts. Now we're starting to see cases coming from the European courts. And this is maybe the result of the mediation directive. As you know, there is a mediation directive, and the judges are encouraged to ask the parties to try to use mediation to resolve their dispute. This has been going on also for many years in the UK. We see a majority of international cases, 75%, but we also handle some domestic cases between two parties from the same jurisdiction. I think this slide has been covered by Kathy, so I will not go into this really. what we see often is really that in the international cases, neither of the parties is very happy litigating in the course of the other party. So they see neutrality as a big factor. And we see that through these procedures, and in particular mediation, parties are able to preserve their business relationships. And as I was mentioning earlier, since most of these cases relate to contractual disputes, parties are very keen to kind of maybe amend a license, amend the scope of a license, and then continue with their business. So they're really trying to limit the damage to their business operations, really, and mediation can be extremely useful for this purpose. We have been conducting a survey recently on dispute resolution, and I'm going to present some very few slides. There's a big report on our website if you want to look at it. But what we have found through this survey, with more than nearly 400 participants, is that parties are concluding contracts which are really international, because parties are based in different jurisdictions, but also when it comes to technology, the technology is protected by patents in several jurisdictions. So in those situations, really, the alternative is to go country by country litigating in respect of each of the patents. That is expensive and time-consuming, and so what we are seeing is that parties are seeing the advantage of moving to their disputes to mediation or arbitration. We see that still at the moment parties are resolving their disputes mostly through negotiations, and negotiations are really effective in many of these IP-related disputes. Then you see that the next way of resolving disputes is through litigation, and that mediation and arbitration are still a minority of cases. So the method of resolving disputes is still mainly litigation. But then when we move to the time and cost of the different methods of resolving disputes, you see that court litigation is much more expensive than mediation and also than arbitration. So clearly these results show that there is a huge potential for these dispute resolution methods. And Luca has already talked about domain names, so I'm not going to talk about these. We continue to have a huge activity in domain names, 3,000 cases per year under the UDRP. But what we are increasingly doing is we're working with IP offices. And this is a new thing that we have been doing for the last couple of years. And in this area, we are working with two offices at the moment. We're working with the IP office of Singapore. And what we have done is, as part of their existing administrative proceedings, opposition proceedings in particular, now they have introduced a new mediation option. And this is really an option available to parties in the course of the opposition procedure. The opposition gets suspended if the parties request a mediation jointly. And we are starting to see the first cases in this area. And some of the cases have been quite effective, really. So far, every case has been settled. And what is interesting is that parties start because they have an opposition going on in Singapore. But what they have been able to do is they've been consolidating into that mediation disputes relating to other oppositions pending in other jurisdictions. So they have added oppositions pending in Malaysia and Indonesia. And then often the result of the mediation has been a settlement agreement dealing with those oppositions, but going well beyond the oppositions. So in one of the cases, for instance, we saw that one of the parties acquired the other party's trademarks and even was in process of negotiating the purchase of a company. So this is something that is working very well so far. Of course, Singapore is not a huge jurisdiction, but it's a good example of what mediation can do in the area of trademarks. We are currently working with the IP office of Brazil, INPI Brazil, and there the situation is quite different, really, to the one in Singapore. In Brazil, of course, it's a booming market. It's a BRICS country. They have a huge volume of trademark applications. I think they have over 100,000 applications per year. and they have a huge backlog in dealing with those applications. And so we are working with the IP office, and they are about to make available a new mediation procedure, which is going to be administered by two different institutions. INPI Brazil has set up its own mediation center, and they're going to be dealing with disputes involving two Brazilian parties. So if the two parties, the applicant for the trademark and the opponent are Brazilian, the IP Office of Brazil will deal with that mediation. But if the dispute involves a foreign party, a non-Brazilian party, then the WIPO Center will deal with these cases. And given the volume of opposition pending in Brazil at the moment and the time it takes to obtain a trademark, we believe that this procedure may be a good way to handle some of the more complex cases. So this procedure is going to start very soon, and INPI Brazil has also indicated that they want to then also handle some arbitrations in relation to both trademarks and patent disputes. So this is probably the most important slide, really, and here what you can see is the settlement rate. So you see that the settlement rate of mediation in our experience at WIPO is 70%, and in arbitration we have more than 40% of cases get settled. So if you are using in your licensing contracts the type of clause that I was mentioning earlier, the mediation followed by arbitration, then you are very likely to find a settlement to the dispute. And we believe that this is a very good thing because really parties really need to get on with their business. And that's really what they want to do, is to limit the problems and move on with their business, not to focus too much on litigation. I will be happy to answer questions at the end of the session. Thank you very much.
Thank you, Ignacio, and thank you, Catherine, for sharing information about this very, very useful possibility how to solve the conflicts. In spite of that, we all know that most of the disputes go for litigation. Therefore, I introduce you with the next speaker, Gregor Schneider. He is a litigator of the OHIM before the European Court of Justice. He's originated from Germany, and before to join OHIM, he has a practice at the lawyer and served as a staff for the Department of Justice in Switzerland. So we all know how important it is to know the weak points of each case at the beginning, and not to ruin this case just because of some mistakes taken already at the first level. So I hope that you will share the information about how it's going on at the higher level, and we all can learn this valuable information. Thanks.
Thank you very much, Ruta. Good morning, ladies and gentlemen. Thank you to the organizers of the conference for allowing me to take the floor and have this opportunity to address you all. I would like to speak about, I was asked to speak about litigation for practitioners, about the particularities of the litigation before the European Court of Justice and its pitfalls. Well, let me first set the context. This is what I'm going to talk about. There's two ways in which European trademark law can grow. One is by preliminary reference proceedings before the European Court of Justice. This is not what I'm talking about, but I'm talking about the left side, which is trademark law arising from case law, direct actions against the office in Alicante. It's a lengthy procedure, as you see, and this was said in the slides by my dear colleague from Geneva. It takes time to get your case settled. When you go against a decision in Alicante, it can take up to 10 years if you go to the different instances. So maybe it's good to go for the mediation before. And another thing which is interesting to take note of is statistics. We have We have, in 2012, we had 278 direct cases against the office, which is 236 first instance cases and 42 appeals to the European Court of Justice. This year, in the beginning of June, we are at 116 cases, direct actions against the office, which means that we are more or less stable. Our 278 cases are something like a third of the caseload of the Court of Justice. So we are being the big chunk of the work of the judges in Luxembourg. What is interesting to take note of, and this is a particularity maybe as well, is, and when you assess your chances, is that if you take the overall numbers, there was in 2012, out of these 278 cases, only in 38 cases the office got annulled. So this is, if I count correctly, it's around 10% in which we are annulled. And if you look at absolute ground cases, in only 3 cases in 2012, we had been annulled. This means we have a very high quality of our Board of Appeal decisions, and usually the court follows what we propose as the right solution. This is to be taken into account when you advise your clients. Let me start with the awareness rising for the particularities of this kind of procedure. We have, I'm putting here down the 2 norms, 2 provisions which are at the origin of this very special procedure. One is the fact that our boards of appeals are independent, so our boards of appeal members are not bound by any instructions, and they're a separate entity within the office, which had been labeled as quasi-jurisdictional, but it is not, it's a part of the administration. So the last word of the office, of the administration, is given by an independent part within the office. They don't receive any instructions. However, when we get to the Court of Justice, when we get to the first jurisdictional instance, there we have Article 133 of the Rules of Procedure of the General Court that says that the application shall be served on the office as the defendant in the case, and on the other parties of the proceedings before the OE, before the board, but they are not the defendant. The defendant in the case suddenly is the office itself. Now, what does this mean? Who are the real parties in this procedure before the court? Because we have this switch from one model, we have in Alicante, we have the IPO model, the Boards of Appeal, non-contentious procedure, where the office is a quasi-judge. We have the switch from the office being a judge to the office being the defendant. Now, taking into account that the Boards of Appeal are independent, and taking into account that they don't have to comply with instructions from the office, it's obvious that there's sometimes divergent case law. This is a natural thing. Different chambers of the Boards of Appeal would take different philosophies, different decisions. Now, it's very difficult for the office to decide, or what shall the office do when these cases come to the court, because then suddenly again, it's the office who is the defendant. And the office, well, we didn't know how to approach this problem. If there is a case which goes against the declared practice of the office. So the Board of Appeal has taken a certain view, and in other cases, other Boards of Appeal have taken different views. So there's divergent case law. What is the office going to do? In the beginning, we thought we can act like an amicus curiae. So we just give our opinion, and we don't have a formal head of claim at the end of our submissions. However, the court clearly told us, well, these submissions which have not a formal head of claim in the end are inadmissible, because you have to have some formal conclusions. So they were not taken into account. The office is not an amicus curiae, but the office can also not be forced to systematically defend all the decisions of the Board of Appeal. And this was clearly, very clearly confirmed in the cases that are indicated here, the Biomet and Kloppenburg case, and had been followed afterwards. So it's very important, especially in inter partes cases, for you to know that the office is not obliged necessarily to defend its own decisions. So what can happen is that, for example, in the Deutsche Ring case, which you can find published, the office said, well, this is not the practice. We also think this decision should be annulled. So there was nobody defending the decision of the office. If it's inter partes cases, it might be that you, as an intervener, will be the only party who defends the decision of the office before the court. And that's why, especially in inter partes cases, it's very important to contact the office and to find out whether you, as the intervener, are the only party defending the decision, which is, in the end, in your economic interest. As I said before, given that there is a special sui generis model, hybrid model, where the office becomes a defendant but really is not the real defendant, economic defendant, what had to be created was a special form of intervention. So for the procedures which are governed by Title IV of the Rules of Procedure of the General Court of the European Union, there is foreseen a special form of intervention. The particularity in our proceedings is, when you compare them to the normal proceedings before the Court of Justice, is that we have private parties. This is what the court said in the famous Kick judgment as well, as regards the special language regime that we have. There's private parties that go against each other. And the same happens in the procedure. Being there private parties, we need a special form of intervention in which the intervener has the right not only to what the normal intervener does to support the claims, the head of claim of the main parties, but to have its own independent claims. So, in this Article 134, there's a special form of intervention foreseen, whereby the intervener can be independent from the main parties. They can ask themselves for the annulment of the decision in aspects which had not been raised by the other parties. So this happens frequently, and it needs your attention. It has consequences. For example, it's different deadlines. Normally you have, for intervention, the normal intervention is Article 115 of the Rules of Procedure. There you have certain deadlines, and you can even ask for an intervention before the oral hearing takes place. The intervention then will only take place in a spoken form during the oral hearing, but you're still allowed to intervene. If you miss the deadline of Article 134, which is the normal deadline that also the office gets to submit a response, you are out, and you cannot accumulate different forms of intervention. There's another thing which is interesting. Normally the intervener can only be condemned in its own costs. But in our special form of intervention, because the intervener might be the real party, it is possible that you, as an intervener, are being condemned in costs, and the costs of the office and the costs of the other party. So this is also important to know. There's a higher cost risk in this specific kind of intervention than a normal intervention. Something else that the intervener can do that, which is different from the normal procedure before the European Court of Justice, it's the possibility of applying for an alteration of the decision of the office. Normally in community procedure law, the only thing, it's French administrative law, which has inspired the community system. You can only ask for the annulment of the decision of the administration. There's one exception in the treaty, which concerns the amount of the fine. So the fine can be altered. But this is the only competence for alteration that the court normally has. But in trademark matters, the court can still alter. There's a competence which is in Article 65(3) of the Community Trademark Regulation that says the court can also alter the decision of the Board of Appeal. Now, given that this is not foreseen in the treaty and there's a certain problem of hierarchy of norms, how is it possible that by simple regulation you can amend the treaty? The court is very cautious when they address this competence. So while in the normal national jurisdictions, lawyers normally will ask for the opposition to be rejected or to order the office to register the trademark, such heads of claim are mostly inadmissible. Because given this stronger principle of separation of powers, this principle whereby the office normally will implement the decision of the court and the court will only annul. This is the normal thing. Court annuls the decision, office implements. All these heads of claims are very often declared inadmissible. However, this is what is possible. The court can adopt a decision for which the Board of Appeal would have been competent. But this means you have to look, if you do your head of claim, for the competence of the Board of Appeal. And the Board of Appeal is not competent for everything in the different kind of procedures. For example, if we talk about the opposition procedure, the Board of Appeal could reject the opposition, but not more. The Board of Appeal cannot register the trademark or cannot allow the registration of the trademark because the Board of Appeal is only active in this kind of procedure in the inter partes case. So there's the possibility of asking for such complicated heads of claim, but very limited to the competences that the board has in this specific case. Let me move a little bit ahead, and I'm coming to an end. Another issue is the scope of judicial review. Even though we are talking in the general court about the first instance judicial proceedings, the judicial review is in a certain way limited by Article 134, 135, paragraph 4 of the Rules of Proceedings, very important, which many lawyers are not aware of, that the parties' pleadings may not change the subject matter of the proceedings before the Board of Appeal. There is no clear definition what is subject matter of the proceedings before the Board of Appeal. It's certainly not the application for trademark registration. It's certainly not the likelihood of confusion. It is what was pleaded before the Boards of Appeal. So you cannot enlarge this subject matter. This means nothing, no factual or legal submissions which have not been made before the Board of Appeal, they cannot be taken into account by the court. So there is a cutoff point. If you have not submitted certain arguments to the Board of Appeal, you cannot submit them anymore. Factual submissions are very limited. However, there's a fine line because in certain cases the court has also said that when you add additional facts which just highlight or deepen the submissions that you have done already before the Board of Appeal, they are admissible. So there is no clear definition of this line of deepening evidence that you have already, or factual arguments that you have already submitted before the Board of Appeal, and new factual arguments, but you can be sure that the court is going to be very restrictive in accepting new evidence before it. There's another thing which is very often not known to the lawyers. Very often lawyers try to limit afterwards their application, the goods and services, the list of goods and services, hoping that by this they can have a different outcome of the court proceedings. But no, this is not possible because what the court does is only checking the legality of the Board of Appeal decision at the time it was adopted. So this means whatever is changing afterwards at the administrative level has, in principle, no impact on the outcome of the court proceedings. Unless, and this is the exception that I'm putting down here, it can be interpreted as a partial withdrawal of your application. So if you limit your goods and services in a way that it can be seen as a partial withdrawal, then it will be acceptable and will have an impact on the court proceedings. Here's what happens if you limit your list of goods and services? Well, it might lead to a proceeding being devoid of purpose. And this is also important to take note. There's two different ways of terminating the proceedings before the Court of Justice. One is the withdrawal of the application, the discontinuance, which is foreseen in Article 99 of the Rules of Procedure, or another possibility, the declaration that the action has become devoid of purpose. If you settle the case with the other party in inter partes proceedings, it is advisable that you go for a declaration that the action has become devoid of purpose, because this will have an impact on the existence of all the earlier decisions as well. This means that automatically all the earlier decisions of the Board of Appeal also have become devoid of purpose. This will not happen if you just simply withdraw the case, because then the Board of Appeal decision becomes into effect. There's also a consequence for the decision on the costs. If you do a declaration that the case has become devoid of purpose, the division of costs is in your hands, because the court will follow. If you say that there had been an agreement about the costs, the court will usually follow this agreement. If you do a withdrawal of the application, automatically it's the applicant to the court that has to bear the costs of the proceedings. And, well, oh, sorry, this was the wrong one. Here comes my last slide. A decision which we had recently, and this is really one of the last pitfalls. Sometimes lawyers do stamps and don't sign their applications to the court. Well, now we know this makes your application inadmissible. Be careful. You have something which is called a regularization procedure, in which many admissibility problems can be solved by the greffe, by the registrar of the court. But if you fail to sign your application, then you're out of the proceedings. Thank you very much for your attention.
Thank you, Gregor, for your excellent presentation. I think we all can learn a lot. And the last one is also my one mistake. So it is good to mention that, because you should be very careful. Otherwise, you will ruin all your hard work. So our next speaker is Frank Sotul. He's ECTA member, European trademark attorney, and he's a founder of French law firm Inlex IP Expertise, with a headquarters in Paris and branches and 6 branches. So Frank will speak about one case which was decided by a court last year, IP translator case, and it was on the list of the hot topics of our previous ECTA annual meeting in Palermo. Now we can look how it is deal in practice with this decision. So Frank, please, the floor is yours.
Thank you very much. I would like to start. Yes, David Cameron will be my guest at the end of my intervention. I would like to tell you that it's a scoop for Peter Müller and the ECTA Bureau. First of all, I would like to thank you, everyone, to be there, because I'm feeling like an avatar, because, as you know, there are so few French speakers in ECTA and other events that it would be certainly my first and my last, because I would like to encourage my colleagues for France to be there more than me, because creating my office in 1995, I'm very young, despite my hairs on my face. And I think that when you want to represent Europe, you have to be there only once and maybe twice. For me, within one time. But I think that I make an appeal to my colleague here, because I noticed on the list of attendees that the French are 8% of the attendees. Can you imagine? France is represented here by 8% people. I don't feel that is a good way for improving Europe, and I think that it's the right time to move, at the right time to wake up from my colleagues. First of all, I would like to tell you that, as you know, we are talking about a British case. It's a very interesting case, because English is my third language, and I'm talking about a British case. It's a very funny life, you know. And Also, I would like to tell you that I changed a little bit the title. I would like to apologize for the extra members because I put it 2S at the end of rule and game because I think that, as you know, in fact, before there are different rules by national offices. And despite of the fact, everybody or myself, I thought that there is one single game with Europe, but in fact, there were a fighted situation between national offices and OHIM. Maybe you know this poster because this movie was a very good success. Before explaining why I put it this poster, I would like to tell you that it looks like me when I'm staying in my Tokyo hotel, because during 2 nights I don't sleep with a jet lag, and I'm staying on my bed like this. It is a really true story. Second point, or more seriously, in order to introduce IP Translator, I would like to tell you that the character on the poster represents the fact that OHIM lost his way in 2 or 3, because everybody knows the 2 or 3 communication, and I think that OHIM lost the way by establishing this communication. The second reflex of this poster on this character is to explain that the national offices have been feeling uncomfortable with this communication for a long time, but nobody heard them. And everybody applied or not applied, and the national offices did not apply this communication, but nobody knows, nobody says, and nobody express the fact that there are different rules in Europe. Also, I would like to support SIPA. SIPA is the owner and the applicant of the trademark IP Translator, and I love very much their slogan, whatever you do cautiously and look to the end. Everybody knows that we apply this rule day by day in our work. But also, I would like to tell you that when thinking into the portfolio of SIPA, I found IP Translator with education providing of training, entertainment, sporting and cultural activities in class 41. And you notice that this strategy of filing is a strategy of global approach. Global approach meaning class heading. But very strangely, after thinking in the portfolio, I saw 2 different marks, Shattered Patent Agent, Shattered Patent Attorney, and Patent Agent. And I was completely puzzled because I cannot imagine why these trademarks apparently have been registered, because for me, the names are completely not distinctive. I cannot imagine that the UK PTO accepted these marks. Maybe there is internal lobbying, I don't know. But from my point of view, how could we logically explain that at the same time, signs with absolutely lack of distinctiveness were registered for these trademarks and refused for IP Translator, as their only difference is the drafting of their illogical specification, because it's illogical to file IP Translator for entertainment, for me, and illogical to file Chartered Patent Agents also for patent and trademark agency services. I'm very puzzling. I hope that a British colleague will explain to me, because I'm just a French and I don't understand this approach. Let me also to remind you the facts on the steps with this case. The case IP Translator will be named IPT case for good speaking. And this case starting with a classical distinctiveness case ruled by the national office. And very strangely, this case brought to the examiner to take a stand, somewhat contradictory with his local practice. As far as I know, the communication of 2 or 3 was not clearly, widely, and regularly applied by the UK PTO. Like from the French point of view, the French PTO did not apply this communication. And I'm very surprised that the UK PTO started with this approach. Further to this decision, we attended unresolved contradiction in the following order. First, the resurgence of 2 or 3 communication, which by extension would prove that the trademark indeed lacked distinctiveness. But at the same time, if you remember the list of services of IP translator, a real contradiction between the claimed services and particularly the lack of any relation between these services and the translation services. It is very strange. This absurd situation led to refer the CG for a preliminary ruling, which the most part tried to redefine the policy of OHIM by this communication of 203. I would like to put stress the fact, and I hope that the people of OHIM will explain me, to put stress on the fact that apparently OHIM and Commission became disengaged from the preliminary ruling first. Apparently also OHIM by a communication that I saw by seeking into the file, the OHIM claimed the confidentiality of their observation. That's quite surprising that OHIM said en route that the observation of 2011 in order to apply to this preliminary ruling is confidential. Maybe it's true, maybe it's wrong. I would like to be very happy to know what is the truth. In one word, I think that the case is very important and very not prejudicial case because it will accelerate the convergence program. And thanks to this, it will be certainly a better point to go ahead from my point of view. The IPT case is interesting on several levels. I remind you 7 points that I would like just to develop very quickly. The 4 first items that I name, the 4 axes, are very interesting because they remind you what is an appropriate trademark should claim in its specification. Amongst these axes, I would like to notice again that the Sickman case was cited several times in the process of the preliminary ruling, and I think that the Sickman case is certainly a very good basis to extend the rules to apply for the drafting of the list of groups of services. And for that reason, I think that the CG decision is not really matured in comparison with the Sickman decision, who was, for me, for a practitioner like me, very efficient. The other point to remind with the CG decision is the challenging of the administrative practice around 3 IDs, the item 5, 6, and 7. Among these rules, I would like to make a focus on the compromised situation of this decision. Because in fact, an attempt to make national offices on OHIM practices coexist through a compromise that places the owner in front of a very difficult choice in terms of responsibility when selecting the list of products and services. For me, it's a very dangerous situation. It turns out that if this ruling has indeed opened doors for a better comprehension of the rules to be applied, is still incomplete, because it brought a convergent situation instead of setting up a real harmonization on agreement on the reasonable, on only reasonable rule, the literal approach. Because for me, I'm sorry, certainly we will discuss or not, the literal approach is the right way. And the second approach is the wrong way because it's not a real word for the IP practice, it's my opinion. In one word, a qualitative necessity to have a literal approach was quite beaten by the quantitative approach that we name all lists of goods or services. That is a very important point that creates a weakness, for me, of the CG decision consequence. After 2 communications raised by the OHIM, a regrettable one in 2003 that hopefully was released, and another one hastily made in 2012 under the pressure of managing the intermediate period, we can, however, notice, and I would like to congratulate OHIM and the national offices who have been able to find a common solution in 1 year. For me, it's a very good point. As of 2013, the future trademark application will be handled with a literal approach. It's a very, very good point, but it's very regrettable that it was mentioned the option to enable the applicant to claim all list of goods or services when selecting the class heading. However, this situation did not resolve the fate of the trademarks which have been protected before IPT case. In case, IPT case has made the situation from controversial situation in 2 or 3, because, as I told you before, there were discrepancies between national offices on OHIM towards a convergent approach in 2012 for landing on an harmonized communication in 2013. But certainly, from my point of view, not a common view in terms of approaches and scopes of protection, because in this decision we are talking about class heading, but for me, class heading is over. Class heading is the past. We have to talk about the class scope, what kind of products, what kind of services, and there is a lot of unused work to develop in order to create a real list of goods or services. But I'm very optimistic in my mind, and I think that I'm waiting a lot from the class heading breakthrough proceeding that is coming at the end of the year, and I hope, thanks to this communication, the clarity and the precision of the list of products and services will be completed. But what about the destiny of the isolated terms? Because they are, again, isolated terms, very difficult to apply in the class headings. It is my question, and I wait and see the next step. That is a table that I established with my team about the positions of the offices before IPT. You notice that there are quite a lot of countries who did not apply the OHIM. That is the first point, and even United Kingdom that I put in red. After that, I established a board on a table about the offices that changed their approach before and after IPT. I was surprised, but maybe somebody from Italy, Domenico or Fabio, will explain me, but apparently Italy is staying in the neutral position between left and the right side. And maybe it will be interesting for me to understand why I put it Italy alone. I'm sorry for my Italian colleague. Another point I would like to tell you that as a stress test, in last April, we have interrogated 2 law firms per country in order to feel them about their position to apply the new rules of the CG's decision in their day work. And very strangely, after doing this, just a survey, it's not official survey, it's internal survey, I noticed that there are, again, in April 2013, professionals who did not change their approach. Who did not change their approach is meaning that for them, CG decision is nothing, or nothing move, we have to wait, or we have not to wait, just that's right. But on the left side, I put in some countries like myself, because I'm an agent of the survey, we changed completely and began to think about the next step to apply the rules in my files. Now we are talking about the consequences of the daily work for a French like me, European trademark attorney, day by day, relatively to the policy of protecting the trademark. As of now, protecting a trademark should take into account 2 main criteria. The main one is a qualitative one, it's my name. It's a literal approach. Literal approach for me should be the first one on the first criteria to apply. But unfortunately, there is also a quantitative one, the unfortunate option to put all alphabetical list of goods or services. For me, to maintain the both sides is not very good situation, because I told you, and we will see for the next slides, that is creating a puzzling situation. But from my opinion, it was strictly associated only to bring the isolated terms back in the global scope of protection, because I don't know what other reasons have been applied to maintain such 2 ways of protecting. And the problem is we stay with optional protection for all list of goods or services that is given to the applicant. You can imagine the responsibility of the applicant and the responsibility of the agent to say to your client, okay, go to the easy way, you click the box and everything is protected. This is a very important point. And I think that this unmatured and compromised solution should change. And I hope that the experts of OHIM, the experts of the Commission, the experts here, presented here, will work to change this way. It is my very deep opinion. That is a table which shows the overview effects of the interpretation of the NIST classification for French. Oh, sorry. For the French, 3 minutes. Really? Okay, I speed. For the French and the OHIM. You will notice that in most of the cases, the French and the OHIM mutually respected their opinion because for trademark file before and after CPT, IPT case, both offices apply the same rule. But mentioned in red, you will over see an exception for the community trademarks which have been filed before the IPT case. For the opposition, for French point of view, nothing changed because we always applied the literal approach. However, still in the field of opposition, the OHIM position changed because even the OHIM did not apply regularly the 2 or 3 communication. It is quite ironic, but it's the truth, because by doing a big screening of the decisions from OHIM, I noticed, I put it here, some practical examples that OHIM themselves, on itself, did not apply the 2 or 3 communication. It's not a rule that OHIM followed. And I don't understand why the OHIM continue to maintain the communication of 2 or 3, and why the CG decision continue to say that this communication, unfortunately, should be maintained or not. My opinion is, I suggest to collapse this communication on 2 or 3, on not only to formally release that the communication on 2 or 12 expressed. That is just a table which shows the difficulties to handle the opposition now, because the scope of protection of the same CTM actually evolves and differs depending on 3 criteria. The date of the filing of the CTM trademark, before an IPT case and after, or the date of the office has issued its decision. You can imagine the responsibility we have in such case. In consequence, I think that now there is a real difficulties to compare between 2 lists of products and services for CTM, and also, from my point of view, the cost charged by the agents will increase because their professional responsibility will grow. For the trademark filings, and to summarize this, I think that it's very urgent for OHIM to provide us with their list of isolated terms to put this option of all list of goods or services render harmless. It is a very important request I do today because I think that is puzzling the practitioner like me. For the renewal, here again, I think that there is a coming rule who oblige the applicant to specify the attention in 4 months period if it becomes official after filing the CTM trademark before IPT case. I hope that it will be applied for the CTM trademark filed with the ticky box because this situation could not be sustained. For the conversion of CTM, it is a real problem because when the CTM will be converted, the rules to be applied will be different. For the trademark clearance, you see that everything no change except for the prior similar trademark filed before and after IP translator. For cancellation action, here again, it will be very important and very very important to deal a contradiction or advice between the date of the filing on the date to submit the use requirement. Because I show you an example on the slide, because sometimes there is an advantage to put the class heading, but sometimes an advantage to keep the alphabetical list. The next step. I told you that I'm very embarrassed to talk about the British case, but here again I would like to help my US colleagues because I think that the next step would be to establish a real strong trademark around three criteria. An administrative one, meaning that the literal approach could be a very good point to sustain the administrative rigor of the trademark. A legal value should be the second option, and second rule to apply, and it would be certainly supported by the taxonomy work and the convergence plan that I hope to come very quickly. And the third one, we should be the economic value of the trademark. But unfortunately for me, to maintain the whole list of goods or services will decrease the economic value of a trademark by leaving an applicant to protect everything for nothing. It is my opinion. Why about not to go to USA versus USE, United States of Europe, by applying their policy? Because I think that in the United States, even if I'm not really enthusiastic with their proceeding of litigation or prosecution, I'm quite attractive with their policy for filings because I think that their database is very convenient. The search in the United States is very clear, opposition also. And I think that we have to take care about this experience to create, with the EU spirit, something approaching to US. I give you some example of comments from my US colleagues. The main interest is the bold characters of their replies. And you will see that they are quite enthusiastic with this CIPT case. And I think that it will be interesting for us to cross with the United States or US practitioners in order to find the right way. Finally, it's the end. Oh yes, it's just the time, I know, sorry. I would like to tell you that Mr. David Cameron will conclude, and you see the slogan, "In Britain can deliver." It is a very important slogan to memorize, and maybe for the video, I'll let the people, do you have the video?
By saying this, I have no illusions about the scale of the task ahead. I know that there will be those who will say the vision I've outlined will be impossible to achieve, that there's no way our partners will cooperate, that the British people have set themselves on a path to inevitable exit, that if we aren't comfortable being in the EU after 40 years, we never will be. But I refuse to take such a defeatist attitude, either for Britain or for Europe. Because with courage and conviction, I believe we can deliver a more flexible, adaptable and open European Union in which the interests and ambitions of all its members can be met. With courage and conviction, I believe we can achieve a new settlement in which Britain can be comfortable and all our countries can thrive. And when that referendum comes, let me say now that if we can negotiate such an arrangement, I will campaign for it with all my heart and all my soul. Because I believe something very deeply, that Britain's national interest is best served in a flexible, adaptable and open European Union. And that such a European Union is best with Britain in it. Now, over the coming weeks, months and years, I will not rest until this debate is won for the future of my country, for the success of the European Union, and for the prosperity of peoples and for generations to come. Thank you very much indeed.
Just last one, let me 30 seconds. I would like to tell you why I let Mr. David Cameron conclude. Because I think that, as you know, that is a British case. That's the reason I would like to conclude with him. But it is very important for me to give you my own conclusion. If the national scene should not be detrimental to the progress of Europe, the other way around is especially true. I think that this IP translator showed that there need to be a close relationship between Commission, OHIM, and national offices to work in the same way. And IP translator proved that it doesn't the reality. I think that it's very important to take care that Europe is 28 countries now, but it's countries with good ideas, like Commission and OHIM has a good idea also. The second point is, you will understand that the message delivered by Mr. Cameron, if you delete Europe by replacing OHIM and Commission, if you are substitute the mention of a referendum, because it's a referendum of Britain, it doesn't matter with the case, but you are taking into account that national offices on the OHIM should work together, I think that IP translator will create a real improvement of the CTM system. Thank you very much, and no question, please, without IP translator for me, please. Thank you.
Thank you very much. I think it was a great conclusion, especially when the Frenchman conclude with an Englishman text. So it was great, and I think we all may be in peace that everything will be settled, and we will find a common conclusions for each kind of questions, in spite we have different. So now it's time for questions. Noting that we run out of time again, I'm sorry. I think we have a very distinguished panel, so I encourage you to use this opportunity and ask some questions. Can you pass back?
My name is De Benedetti. I'm from Italy. I'm a member of the Council of the Italian Association of IP Consultants, which is the body officially recognized by Italian law as a representative of a qualified IP profession. In this quality, I talked recently with the Director General of the Italian Patent and Trademark Office and with the Director of the Trademark Division about the communication, the common communication of OHIM and national offices, and particularly the position taken by Italy in connection with the value given to the community trademark registered, filed and registered prior to IP translations, and claiming the class heading. You mentioned that the position of Italy was quite isolated, and I discussed with them, and they admitted that it was that position was taken by mistake, and probably they will modify in the next future their position in this connection. I take this opportunity to mention one comment, a personal comment in connection with this the entire question, and my comment is that there is this strange practice under which the administrations, both OHIM and national offices, sometimes try to make a law. The 2003 communication of the president of OHIM, according to which class headings would correspond, to the protection of the entire list of goods or services of a class, was something that was taken outside of any power given by law to the president. And I think that even this common communication under which the OHIM and National Office established what would be the protection recognized to the application and registration, trademark registration prior to the IP Court of Justice decision when these registrations were claiming the class headings. I think is something which is taken outside of any power given by law to them. It is true that they should decide something in connection with the oppositions, which is administered by the offices, but I don't think that this is the right way to act and to take this kind of decisions, which are very delicate and could be tomorrow contradicted by judge decisions, national judges, or the Court of Justice of Europe. Thank you.
Okay, thank you for your comment. Any comment? No? Any question? Everybody's starving. Okay. I hope that this morning's session... Do you have any comments? No? Okay, there is a question. Okay. Please.
Sorry, Gordon Humphreys.
Be short.
It's a quick question to Ignacio. In the light of Kathy's comments before you that it aids mediation when one of the parties is reasonable, when they're not reasonable, what problems have you encountered on enforcement of settlement agreements post-mediation? Do you have any feedback on that?
By the time the parties come to mediation, they have agreed to come to mediation. So they come to mediation because they want to come to mediation, and at any stage of the mediation, they can step out of the process. So what we have, really, our experience is that when the parties reach a settlement agreement, they comply with the settlement agreement. So we don't tend to have repeat customers who kind of did not comply with the settlement agreement. That's quite unusual.
Thank you.
Okay. Some more? No. Okay. I really thanks all the speakers of this session, and I hope that all morning session gives you many practically useful information which you may use when you are practicing at your home. So all presentations will be put on ACTA website after the conference, so you all will have an ability to read it carefully and use it. So on behalf of ACTA, I'm delighted to thank you all for your time and for your great speeches, because I think it was excellent one. So, and before closing, I will give you some presents of ACTA, but then I have some technical announcements, because you have received these vouchers for the lunch, and you should pay attention in which restaurant you have to go, because there are different ones. So thank you very much.